Reminders of your ongoing obligation to declare interests. And just to remind members that this meeting will be recorded and all mobile phones should be switched off and not just in silent. They may interfere with the recording. Tablet devices as well obviously can be put on mute by pressing the FN key followed by the F8 key. Overview of today's business. We will have a department briefing on the Code of Conduct for Councillors and the draft affirmative regulations on transitional provisions for shadow councils. So we'll just move on to the apologies, and we have an apology from Anna. Are there any other apologies to record? If not, we'll just move on to the next item, which is the draft minutes. Members, you've been provided with the draft minutes from the meeting on the 13th of May at page 4. Are you content to agree the minutes?
Agreed.
Agreed, thank you. And we'll move swiftly on to item 3, which is the departmental briefing on the Local Government Code of Conduct for Councillors. The Code of Conduct, which has been laid in the Assembly today, is tabled at page 10. And also tabled is the synopsis of responses to the consultation and a letter from the Minister apologising for the short timescale. The draft code was considered by the committee last week by correspondence only. As agreed at the previous meeting, and no comments were received from the members by the department, it is anticipated the code will be brought to the Assembly for affirming on Tuesday the 27th of May. The Permanent Secretary is here at the request of the committee and will outline the reasons for the meeting today. So with that, can I welcome Leo O'Reilly, the Permanent Secretary, Linda McHugh and Julie Broadway. You're welcome this morning. The committee will be briefed afterwards then, again on the Code of Conduct. So if I can ask you, Leo, if you want to brief the committee.
Thank you, Deputy Chair, and thank you for you and your colleagues' agreement to hold this special meeting of your committee this morning. As you noted, I outlined the background here in my note to the clerk to the committee on my letter of the 8th of May. Essentially, just briefly, members may want to come back on any of the points, but essentially, to understand what has happened here is it's really looking at the timeline of events from effectively from the 2nd of May, when the consultation on the regulations formally closed. The consultation on the code closed on the 30th of April, but we'd had a few requests for further inputs after that date, so the effective date for closure of that consultation was also the 2nd of May. And it was really the sequence of events since the 2nd of May, because obviously in the closure of consultation, and inevitably what happens, often comments come in at the very last minute, which is fair enough because there is a closing date and people can submit things up to the closing date. In both cases we received, as the briefing to the committee indicates, 20 responses for the regulations and 21 responses for the code. Some of the issues raised required us both to go back to our legal advisors and Departmental Solicitor's Office, particularly in relation to the regulations, because some of the points needed the text of the regulations reviewed. Some of the issues in relation to the code required us also to consult elsewhere in the department, because some of the issues raised touched upon the responsibilities of other parts of the department, and obviously significantly in relation to the planning side of the department as well. And basically it was the sequence of events then coupled with the fact of the completion of the passage of the primary legislation itself through the Assembly at the end of April, and we got royal assent to the primary legislation, as you now know, on the 12th of May. But obviously we couldn't move to bring material forward to the Business Committee before the legislation actually became law, and it only became law on the 12th of May. Once we had completed our work on both documents, obviously there's a very tight timeline in terms of bringing material to the Minister, who cleared it very quickly in one day in one case, But that is essentially then why the material was only able to be brought to the committee at the relatively late stage, as I explained. What then caused, of course, normal circumstances, that would just be something we processed, but then we ran up against the 22nd of May for the elections, and the fact that in the week or so after that, a week or two after that, we expect the new councils to want to have their first meetings, and obviously it is highly desirable that particularly the regulations are in place to allow them to begin to commence work fully in what is referred to as the new councils and the regulations, but also for the purposes of things like, for example, the appointment of the new councillors, that we would have the new code of conduct fully endorsed and signed off by the Assembly, ideally before the councils come into operation. So, in a sense, it was a squeeze at one end in terms of the completion of the consultation the 22nd on the 2nd of May. The elections and the events immediately thereafter on the 22nd of May, that created the request from the department to the committee to have this special meeting today to consider both the regulations and the code. Thank you.
Okay. Thank you. I'm sure I know you appreciate the fact that we did reluctantly agree to this meeting today, and I know that many of us weren't terribly happy with the situation, given that sometimes you think I didn't quite know this was coming up. It was a little bizarre, but we are where we are now, and we have agreed to the meeting, so we'll continue with that. Do you want to walk us just through the brief in some more detail to what we're agreeing this morning?
Well, I'll give an overview, because we have other colleagues here who can respond to more of the points of detail. But as you know, what you have before the committee are both in the regulation.
Taking the code first.
We were going to propose, Deputy Chair, to commence with the Code of Conduct for Councillors, which I understand has already been reviewed in earlier drafts by the committee on a couple of occasions. The code, as you know, is based partly on the existing voluntary code that applies in councils, but also draws upon similar parallel codes of conduct for councillors in Britain, and we've drawn on material from that. It also draws on the issues around, for example, the Code of Conduct for Standards in Public Life, so we've drawn on that material as well. And then particularly the planning material does draw heavily on similar documents that exist in local government in Britain, in terms of the role of councillors, and in particular the distinction that you see in the code between the role of councillors who are members of planning committees and the role of councillors who are not members of planning committees. It's, in a sense, it's like all these things. You might say it's stating the obvious, but sometimes it's important to formalise the obvious and put it down. And certainly, it would reflect the sorts of guidance and standards that certainly apply, for example, to ministers at the moment, but also to civil servants, particularly within the DOE, working on planning issues, the type of approaches we would expect them always to take in managing planning applications and planning decisions. The regulations, as the title tells us, are transitional regulations necessary to manage the situation where we have both what are referred to in the regulations as the new councils and also the existing councils operating in parallel with each other. So basically what they do is they provide mechanisms to allow the new councils to begin to come into operation, to begin to perform certain functions, while at the same time enabling the existing councils, which continue to have all the responsibilities to discharge right up until the 31st of March next year. So the regulations address a number of issues to enable both the existing and the new councils, as it were, to operate alongside each other, and also to make practical arrangements such as the requirement for the existing councils to provide the new councils with administrative and other support, and also the requirement on, for example, departments in the Housing Executive to provide information as necessary to the new councils to enable them to begin to put in place the arrangements for the future operation. That's just a could go into more detail, but it was just to give an overview of what the two pieces
I mean,
before you're about.
if we maybe try and get into the specifics of this,
Yeah.
would it be helpful if you were to outline, I mean, we saw previous drafts, it might be helpful to outline where in terms of things there's either been changes where you've introduced things, or even alternatively where issues have been raised and you felt there wasn't a need for change type of thing. If we go through those specifics and those, it might be, sort of helpful to the code.
Yes, if Mylene can join us.
Can we start
For
with the
that?
code for that purpose?
Yes.
Yeah,
Chair.
that's the agenda.
Yes, that would be great. Thank you.
If I can just, while Mylene's getting ready, just sort of give a brief overview. We received 21 responses. As the code was issued before the consideration and further consideration stages of the bill, quite a few comments were raised about issues actually that were subsequently dealt with by amendments to the bill. So, for example, appeals mechanisms was an issue that was raised. Also, the issue of allowing the Commissioner to deal with minor complaints without having to go to a full investigation. Another issue which quite a few respondents raised. And some people asking for further information about the apportionment of costs of the Commissioner's office, and also in relation to the various pieces of guidance that we would be planning to issue to supplement what's in the code. So, for example, a lot of questions about how the Commissioner would undertake investigations, also about the planning elements of the code, exactly how it would apply in relation to planning. And these are things that will be supplemented by not only the guidance that the Commissioner will be issuing, but also the guidance which the Department will be issuing in relation to planning. Several respondents also commenting on the Code of Conduct for officers and how the protocol between the Code of Conduct for officers and Code of Conduct for councillors would, basically apply in both cases. So those were the more general issues which will not be dealt with in the code. They'll be dealt with actually in the other pieces of guidance. But if Mylene can then take you through some of the issues where we have either amended the code as a result of responses that were made, that have been made to the consultation. So, Mylene, do you want to?
I think if I just highlight, first of all, that there are two changes that we are making to the code. The rest of it, queries that come forward are relating to really clarification that we've tried to do by restructuring the final version of the code to make, we're not saying anything different, we've just clarified it a bit better. First of all, I deal with the requirement by councillors to report breaches of the code, and this is an issue whereby a councillor, if he believes another councillor is breaching the code, will be compelled to report that breach. And some respondents suggested that this would be quite difficult to police. The reason why it was put in initially was something that existed in other codes, in other local government jurisdictions, and we thought we'd put it in to see what the reaction was to it. But considering the responses, we decided that yes, it would be very difficult for this to be monitored appropriately, and we're going to remove that requirement from the code. It would be quite onerous on councillors when a councillor does not report on another councillor who may have breached the code. It would put that councillor in breach, and it would be a very, very difficult situation to address. So that has been removed. The other change that we're making is in relation to the term spouse that is used in the disclosure of interests. Some respondents identified that the use of the word spouse is outdated because now there's civil partnerships, etc. And we agree that that needs to be addressed. So the paragraph that relates to that will now require a councillor to declare any pecuniary interest, direct or indirect, that they may have in any matter coming before any meeting of the council. So it's up to the councillor to make the decision that if the interest has a bearing on his own personal circumstances. And that's where the main changes are. Any other changes really relating to clarification, and I can just briefly go through some of those with you now. Some respondents were very interested in the guidance and the training and surrounding the code and wanted to know what was happening about that. and we were able to clarify that that is being taken forward elsewhere with the local government training group and the Commissioner. It's not an issue for the code itself, but we welcome that being made, so we've been able to clarify that. The application of the code to existing councils was another issue that was raised, and people wanted to know if it was going to apply to councillors who are appointed to the new council, but what happens to councillors who are already in existence during the shadow period, what would happen on that? And provision is being made in the regulations that Tracy will be talking about, so that both existing councillors and councillors of new councillors will be subject to this code. Excuse me, there was a reference that was in the consultation which referred to the Commissioner building up a body of precedent, and people thought that that meant that the Commissioner would be creating a benchmark to apply to other applications of breaches, and we took the point that that wasn't the intention of what the department had. We were trying to highlight that having the Commissioner in place at this time, with the experience that comes with his position, would ensure that difficult and sensitive issues will be handled professionally and provide assurance to councillors over the formative years of the new councils. And the department believes that each case brought before the Commissioner will be dealt with on its own merits, so each case will be dealt with as it comes, and each one will be very different, and it's not that there would be a sort of a standard approach, because each case must be dealt with separately. The consultation also dealt with the provision of indemnities, where we want the proposal to amend the 2012 order to take account of the new ethical standards framework, which is similar to what they have done in England. There was support for this, and people asked for further clarification on this. And one issue that was raised was in relation to putting a cap on costs. The indemnity provision takes account of the new ethical framework, which will not hopefully place an additional cost on councils. It will ensure that where a council has decided to provide an indemnity in relation to a code of conduct case, that it must be repaid if a councillor has been found to have breached the code, if the indemnity or insurance policy would otherwise cover the proceedings leading to the finding. A number of respondents made mention to this cap that exists in Wales. And this is a voluntary application that councils have in Wales, whereby they have put a cap on the amount of indemnity provided, which is set at £20,000. Councils as a body corporate are empowered to decide on whether to provide an indemnity and ascertain whether their specific insurance provider would cover it. And a cap is seen as a means to protect the proper use of public money. And it was an issue that was raised by the Public Ombudsman in Wales, because he felt there was too many councillors were just immediately going for indemnity, and it was costing in excess of public money used. So the department has taken on board what people have said. It's something that we will consider with the Minister to see if he would be prepared to look at this when the code is being reviewed in 3 to 4 years' time. But we're allowing councils the opportunity to consider what's happening in Wales on a voluntary basis, and we'll see how we'll keep a watching brief on that during the time between now and when the code is revised. Some respondents also indicated the protocol on relations between councillors and officers that exists. They felt that that should be part of the code or an annex to the code. It was decided that that would not really be an appropriate means to have the protocol as part of the code which the Commissioner is making adjudication on. It is seen as a linked document between the Code of Conduct for councillors and the Code of Conduct for officers, and it is currently being developed and updated. And both those taken for the Code for officers are in agreement that the protocol should be a link between those two documents. Yes, issue of surcharge was raised. Some respondents felt that the requirements regarding surcharge should be included in the code, so councillors are aware what their requirements are in relation to that. Others felt that surcharge should be removed, and therefore it shouldn't be an issue. As the committee are aware, Section 109 of the 2014 Act provides the Department with a power to remove the legislation provisions relating to surcharge by subordinate legislation, and we've considered that whenever the ethical standards has had time to bed in, and we'll put a paper to the Minister to consider at that stage, see how it is going on. There was reference to terms that are used, family, friends and colleagues, and we've taken that on board, but it's just a minor tweak that we will address that, so councillors know exactly what their position is. Yes, there was an issue in relation to if somebody had if a person is known by a councillor who is either holds or is a candidate for appointment to any office in a council. Again, there was respondents wanted some clarification on what we meant by the term office, and again it was just a clarification on that the department would consider this term as including posts, position or employment and applying to all appointments within a council. Any other lobbying and access to councillors, again, this is more of a clarification. This area is going to be addressed in training and capacity building programme being brought forward by the department. The department agrees that the wording of this part will need to be aligned with the part regarding planning matters, and will do so where possible, and we've tried to do that. Any of the other queries that came out of the consultation related to planning, and maybe
quite a lot of the queries were just simply asking for clarification of, terminology, and we have rejigged the code to actually hopefully make it clearer what is meant by it. So there's really only two places where we have significantly changed what is there. One is in relation to this issue about councillors having an obligation to report breaches of the code of another councillor. And I mean, both the Commissioner and I think Nilga's view was that would be very onerous on councillors. It would be placing actually an undue burden on councillors to have to do that. And if they didn't report another councillor, they could themselves be in breach of the code. So that's one of the major changes that has been made. And the other one is in relation to the term spouse, and that has just been clarified so that it's any direct or indirect relationship. So those would be the major changes in relation to the code.
Right, well, thank you for that. And before I bring other members in, can I just ask you a bit more on the appeals process? I know the department has been, the Minister has actually indicated that he may need to bring forward a further bill to provide separate adjudication process within the ethical standards framework. And obviously this was originally to be in, contained within the Code of Conduct. Could you give us an update on where that is?
Yes, we're really scoping out what needs to be done in relation to the appeals process, and getting all of the various legal advice that we need to ascertain, one, what is needed in a future bill, or if a future bill is needed, and we're in the process of getting that legal advice. And we would aim to have a paper to the committee before recess on what the position is on this.
I mean, clearly, in relation to this, we needed to determine before we brought in the code, and either consider, do we leave bringing in the code until we're absolutely certain of how the appeals process will work and whether or not an adjudication panel is required, or do we bring it in but not start the sanction part? Because it would be very unfair to have investigations if there was no clear line of sight through to conclusion. So the Commissioner for Complaints has said that in the interim period, his office will both investigate and adjudicate until such times as an alternative process is set up. So we're in the process now of as Julie said, seeking legal advice on exactly what is required. We'll also have to talk to the Department of Justice and the Court Service about how the appeals process will actually work in practice to make sure that that all aligns. So there's a fair bit of work going on in the background to this before we can be absolutely clear exactly what is needed now in legislation.
Okay, so in the meantime, the Commissioner for Complaints will be dealing with anything in the interim.
Yeah.
Advises. Do you want to come in
Yeah,
and
just
on this
on
issue?
that point. So, to be clear, I mean, if we take sort of a real life example where there's a complaint made against someone, you're saying that the Commissioner then investigates and adjudicates in the absence of knowing what the appeal mechanism would be?
Oh no, there will be the appeal mechanism because the legislation now clearly says that there will be an appeal to the High Court.
Okay.
As you are aware, the Commissioner for Complaints had an issue with that, and that's the part that we're trying to bottom out.
I mean, I wonder in relation to that whether or not, I mean, again, so I'm trying to think a little bit aloud in this, whether there might be some merit in simply putting any investigations on ice until the appeal mechanism is put in place. I'm not sure it's particularly satisfactory to have a situation where there is in legislation mention of appeals mechanism, but we're not quite sure what that's going to be, who's going to be dealing with it, there's going to be legal advice sought, etc., etc. And then you have the first stage happening before the second stage is really put in place on it. Now, it strikes me that one way or the other, the second stage should be a matter of a few months in that regard. And I just wonder, I think it could get quite messy if we have a sort of an interim position on that basis on it.
Yeah, you're absolutely right, and we are quite clear that, whilst we can bring in the code to commence the sort of sanctioning process for breaches of the code, before we're absolutely clear what the full process is, would not be good.
So in terms of then, from the point of view of the are you going to bring in the sanctioning regime in a separate bit linked in with the appeal mechanism, or how do you intend to bring that in, or what's the trigger mechanism for any form of sanctions?
That's what we're trying to work out.
We're actually trying to get the legal advice on all of this, and also the discussions with the Department of Justice and with the court service, so that we can work out when we need to commence the various provisions. And I mean, I think that we need to commence all, we can commence the code separately, but the issue of investigations, adjudication and sanctions is something that would probably be best to be commenced all at once rather than bits of it.
So by bringing in what is this current code,
Yes.
obviously whenever it comes into play, at this stage, until the other mechanisms are put in place, that won't permit an investigation or a sanction to take place at this stage. That will have to be triggered at a later point.
Yes.
Exactly.
And it may be that that's only a couple of months, before
Yeah, no, I
we
appreciate
have
that.
all
I mean,
what it's
I
going to
think
be.
it's
Yes.
they are clearly something which, because of the way obviously the legislation is there, that have got to be all together in the same
Yes.
package in that regard, or else it wouldn't make sense in it.
No, and we couldn't be left in a position where investigations were ongoing, but there was no ability to bring that to a conclusion.
Chair, just a separate point just as well on it, on the issue of those parts of the code, because I think it's 1 to 8 which deal with the bulk of stuff, more or less takes place then once these are through. I think it's section 9 deals with the planning stuff, which will come in later. I mean, at first glance, I haven't seen any particular problem with the planning, but the only point I would make is maybe worthwhile that we have a bit more detailed scrutiny of the planning side, given the fact that there's a lot of stuff that needs to come in fairly immediately, and to be honest, the level of scrutiny we're in a position to give it is going to be limited. But there is that wee bit of window opportunity to make sure that we're getting it right as regards to the planning side. And I think it would be important that we do take a bit of time between now and that coming into effect to see whether there's any adjustments need to be made, and whether, maybe somebody said, look, this is all fine. On the other hand, there may be some sort of further regulations are required to tweak that and that sort of things. I think that would be.
Yeah. Peter, just
can do that.
Just can we just pause a wee second? I think Lord Mayor was wanting in on the appeals.
Yeah, yes, as a point, a supplementary on what I have some reservations about this process and the way it's going in relation to the Commissioner of Complaints. I'm not quite sure how long it takes a complaint to be processed, but it's certainly not processed within a week or 10 days. At least that's my experience of it anyway. There may be, and that's no reflection on the Commissioner's office, because I recognise they've got a workload. So we're going to give this all over to them and say, right, you deal with it in the interim. What do we call the interim here? Are we talking about a year? Are we talking about 2 years? Are we talking about 2 months?
I suppose that would depend on, first of all, isn't a further bill required to set up an alternative appeals mechanism, or sorry, an alternative adjudication process through an adjudication panel? And if that's required, how long that takes to get what will be a new piece of primary legislation through. Now, it'll be a short bill, but it will be a bill. So I suppose we are probably looking at a year to 18 months.
Yeah, that's what I thought. Sorry.
Sorry, thank you. Just to emphasise that what we're doing at the moment urgently is seeking pretty senior legal advice just on the, as you know, this issue has arisen because of concerns identified to us by the Commissioner of Complaints. So the focus at the moment is actually to as it were, earth those concerns and to establish clearly what are the actual issues of substance here, because that in turn, only when we have that, we'll be able to reach a view as to whether a new bill is actually required. Now, one point of view would say it is, but until we get that definitive advice and we're clear on the need for a further bill, once we get to that point, we'll have a much clearer sense of the timeline then required to take forward a bill, and also significantly to put in place the alternative adjudication and investigatory mechanisms that would be required.
So this is just a late revelation that has been revealed?
Well, it's as a result of the amendment that was made to the bill and the introduction of an appeals process to the High Court. And the Commissioner for Complaints view that that will undermine his constitutional position.
Yeah, that's the
nub of it.
The issue that arose here.
Well, yeah, right, okay, I've heard what has been said, but I have still the concern about this, and I know you're talking about a bill here, and a bill is a bill, and there's a procedure and a time factor and all of those things, but I think, this is not as if, we heard about the reform within the past couple of weeks. This has been on the agenda now for 3-4 years, and we come to today on the very eve of the election to the new councils, and we discover that we still haven't got our whole procedures in place, legislation in place. And as you rightly say, it's going to take a minimum of 18 months to complete this. So we'll be doing well to get that done within even this mandate.
And as I said, it's a direct result of the amendment that was made to the bill.
The only thing I would say just in relation to that on it was, in terms of being as quick off the mark as possible, the one bit I'm a little bit disappointed was, we're obviously a few weeks since the bill went through. Prior to that, there was the further consideration stage, which the amendment had already gone through at consideration stage. Prior to it going through at consideration stage, it was fairly obvious for a number of weeks beforehand there was going to be an amendment which clearly seemed to have widespread support in that regard. And I'm just wondering, in terms of getting the likes of legal advice on the best way forward, that was, I suppose, when we look back now 2 or 3 months ago, whenever that was at least getting flagged up. And there doesn't appear to be a great deal of focus in on that legal advice of what was inevitably coming down the track. In relation to that, there does seem a wee bit of slowness of response in that.
Yeah, and I suppose it took some discussion with the Commissioner for Complaints to actually pin down his position on this. And at the same time, we were going through the consideration stage, the further consideration stage, the final stage of the bill, and all the ramifications and all of the legislation that's falling out of it, and a lot that had to be done by the 27th of May. So I take your point, but we've been moving as fast as we can on this, and as Leo said, we're now seeking council advice. So we're absolutely clear of our legal position.
Yeah, I think what's implicit in what's being said is that if the Commissioner for Complaints had brought an issue to us and the collective view and the Minister's view was, yes, that's a substantial issue we need to address, but as you can pick up, we still have some points we want to clarify in our own minds as to the precise nature of his concerns and how they could be addressed.
And sorry, and is that where the real issue is, that within the department rather than the revelation of recent times?
Well, as Linda has said, the amendment was made to the bill, and at that point the Commissioner for Complaints had highlighted to us and to the Minister his concern about the implications of this mechanism of appeal to the High Court for his position. So it's been working through both, first of all, several meetings to understand with him precisely the nature of his concerns and the basis for them, and then to move forward from that to seek our own advice on the nature and the substance of those concerns.
But Mr. Rowley, do you expect that legal advice to be back with you within 48 hours of asking for it?
No, not when it's council advice.
No.
It does take a bit longer than that.
72?
It's normally several weeks.
No?
No, I come
Okay.
We can and will
Press for it.
press for it urgently, given the issues of substance you're identifying.
Members, I'm just aware that Catherine and Tom had indicated earlier, and I know Alban, you want to come in this point. I just wanted to check whether
Mine's different points.
different points. Okay.
Well, I just really wanted to clarify the position. The objection made by the Commissioner of Complaints was that really his constitutional position at law was being undermined by an appeal mechanism
The High Court, yes.
to the High Court. He's not rejected the idea of him investigating, but he will not adjudicate
Yes.
in relation to any sanction that might be brought.
Well,
Is that the current position?
in the interim, they have said they will look at the issue of both investigating and adjudicating. But in the meantime, in the knowledge that we would be bringing forward, if necessary, another bill.
Yes,
Yes.
if that is,
Yes,
if
yes.
Council indicates that that is a necessary
Yes.
bill to bring forward.
Yes.
Yes. But we still have this gap, and it's difficult to anticipate how that will be filled until you receive that expert legal advice.
Other than by the indication from the Commissioner that he will continue in the interim to perform the investigatory
And the adjudication process until such times as an alternative mechanism is established.
Yeah. Okay. Thank you very much, Chair.
Okay, thank you. Can we move then back to the planning issue that was raised and ask you if there's anybody in particular you want to address that? Those points that Peter made.
That's about
Welcome, Fiona.
Very much, Deputy Chair. In relation to the planning element of the Code of Conduct, we received 6 responses from consultees. Most of these responses commented on the need for more clarity on the area of lobbying and the need for guidance and capacity building and training. We've covered these elements before with the committee. In relation to the clarity in relation to lobbying, we have amended slightly paragraph 9 in relation to lobbying. The fundamental message of paragraph 9 remains the same, but we hope we have provided clarity in changing some terminology. In addition to that, we have removed duplication, which was causing some confusion. That was particular paragraph 9.7. which was mirroring paragraph 7.4, so we have removed that because it appeared from respondents it was causing some confusion. In terms of the capacity building and training and guidance, we will be developing this, we're finalising the development of the guidance, which will enhance the code and provide additional clarity on the aspects of the code. In relation to capacity building and training, we have prepared a programme of capacity building and training which will commence rollout following the elections. In relation to the detail respondents, one respondent considered there was no need for a planning element of the code. The department was not persuaded by this argument, given its commitments way back as far as 2009 that there would be a separate element of the code, and the significance of the transfer of planning to councils. We have added a paragraph at the outset to ensure that the planning element of the code is read in conjunction with the full code, that it is all one and not separate. One respondent questioned the need of, as to whether it was entirely appropriate for councillors who were on a planning committee to attend public meetings. We have researched this quite in depth, and best practice would suggest that it is entirely appropriate as long as the adherence to that a councillor doesn't give an opinion for or against a planning application before the material considerations of that application have been considered. On the whole, these were generally the thrust of the respondents in terms of planning.
Chair, just on that, I mean, you mentioned about the guidance then that will be coming out. When do you envisage the guidance being ready, or at least a draft of the guidance being ready?
We are well. The guidance is well developed. We are currently working in tandem with the Commissioner in terms of his guidance. We would be hoping to consult on this guidance post summer recess. Obviously, it will come to the committee. The guidance will come to the committee at that time.
Chair, I mean, I'm just suggesting more than anything else. I mean, there's a certain urgency in getting this code of conduct through, which means, you know, probably if we were told this was happening in 6 months' time, we'd probably be spending 2 or 3 sessions going through a lot of stuff in detail. I'm just wondering, because we've obviously a wee bit more time on the planning, but it's important to think it's got right. So I think we do, whenever it comes to it, need a wee bit of time looking at the guidance just to make sure that, you know, there's nothing that leaps out and says you've got this badly wrong in a particular area or whatever, but I think it's something we need to actually go through in a reasonable amount of detail, because it does strike me the planning changes from a cultural point of view and a political point of view are probably the biggest single leap that councillors are going to face. And you know, there's going to be a lot of challenges out there, but shifting from that position of simply commenting on planning applications to actually taking decisions, I think a lot of people haven't really got their heads around that in terms of the implications on that side of it. I think it's important that we ensure that it is got right, and we have that wee bit of time. I think it's probably, maybe whenever the guidance comes, is the best time to look at this again, just to make sure that both the conduct and the guidance stuff is got right on that point.
Yeah, Chair, we are absolutely convinced the guidance is essential. It will enhance the code and provide even more clarity. That, in conjunction with training, in terms of practical training and role play training, is also essential as planning transfers to council.
Okay,
Chair, just on the guidance, is that the overall guidance? Because I note one of the queries from Nelga was around the rights of councillors, and you said that would be in guidance as opposed to within the code itself. So is all that guidance that Mr Weir and others have been asking about, is that all rolled into the one, or will there be separate pieces of guidance?
There'll be separate pieces of guidance, because there'll be guidance issued by the Commissioner and there will be guidance issued by the Department in relation to planning. Those aspects also is something that can be looked at whenever the training and capacity building programme is being rolled out. That's something that could be dealt with there as well.
Just can I add, we're working very closely with the Commissioner in terms of guidance to ensure there's no conflicts in relation to our guidance and his guidance, and we will hopefully be meeting with him in the coming weeks to ensure that's the case.
okay, Catherine.
Thanks, Chair, and thank you very much for your presentation. Just a couple of points, and I would be concerned in relation to the lobbying element. There's an expectation out there that councillors going in there to make plan decisions for constituents, and you know, it's all right saying guidance, but in setting out guidance for councillors and the conduct of councillors, we also need to look at how we get the message out to the general public about their new role and responsibility and what we're doing. And I don't know how we're going to do that, but I'm sure the department will be. That's out through the council itself, or something we need to look at. That's one element. And maybe you can touch on that. In terms of the code, we are reviewing the code up here in the Assembly. Code. Have you taken anything from that, or have you looked at it? Obviously, I know we're time bound now in terms of some of the stuff we're doing.
Yes.
I'm just wondering, is there any elements?
We're aware of the fact that the Assembly's code is being reviewed, and this is something which, should there be any amendments made to the code, that the Minister may feel that we have to revisit the Code of Conduct for councillors. We'll do that. We're keeping a watching brief on what's happening about the MLA's code, and the Minister will consider that.
In terms of communication, we recognise the importance, and we have developed a communication strategy which will cover both internal communication and external communication. That will again be rolled out post-election in terms of capacity building and training. But yes, that is a very important point and pertinent point, and we've taken that on board and developed a strategy in light of that.
Just in terms of guidance, guidance is guidance, can be read whatever way. Is it in statute, or how do we nail it down in terms that members do adhere to the guidance that's there, you know what I mean? And also in terms of the reporting mechanisms in relation to this here, was mentioned earlier on, mentioned councillors not making complaints against other councillors. In terms of the reporting mechanism for, say, the members of the public, is that more accessible, or how is that in terms of making complaints?
I know that the Commissioner's Office is producing leaflets on and putting something on their website for members of the public, how do you complain? So it will be in the aspect of their website that deals with the Code of Conduct for councillors.
Right, and just finally, Chair, obviously like everything else, it's going to be tried and test cases, over a period of time. I take it there'll be an opportunity to amend regulations if needs be, or whatever, because we can't exactly predict what's going to happen.
Yes.
We certainly have case law that there are things that have happened in the past. But in light of the council, I'm only concerned because council are now taking over the planning element of it. And something maybe we haven't foreseen, and councillors going into it haven't foreseen. Just wondering if there's an opportunity maybe in the future to look at amending regulations if the requirement is needed. It may not be needed, but
well, we have already said that there will be a root and branch review of the whole process a couple of years down the line, to look at whether this system is working or not.
Thanks, Chair. Thank you.
Okay, Tom, are you on back in, or are you?
Chair, I had a general point on the general rules around the Code of Conduct, and it's around 2.7, 2.8 and 2.9, which basically 2.7 is saying that the Code of Conduct only applies when you're in your role as a councillor or acting as a councillor. But then 2.9 goes on to say, which seems to be an overarching one, says conduct which could easily be regarded as bringing your position as a councillor or your council into disrepute. So basically, I feel that's the overarching one and almost dispenses with the others, because almost anything you would do in life probably could relate back to bringing the council or your role as a councillor into disrepute. So I'm actually wondering, is there a conflict in those 2.7, 2.8 and 2.9 in itself? I think I raised this at an earlier stage in an earlier committee meeting as well.
Yeah. 2.7 is when you must observe the code, and it's clarity. That's usually councillor when he's acting as a councillor doing council business. So when you conduct the business or are present at a meeting, when you act or claim to act or give the impression you're acting in the role, or when you act or claim to give the impression you're acting as a representative of your council. 2.8 goes into if you're on an outside body and that has its own code, then this particular code wouldn't apply. You would have to give adherence to that code. So there is a separation there of when the code applies, and that's what we're trying to get across in those two paragraphs.
I accept that, but then when you go to 2.9a,
2.9 is this has come out of other jurisdictions where people who were.
by the way, sorry, I'm not objecting to
Oh
it.
no,
I'm
yes, it's just clarification. Yes, I appreciate that. For example, in England, there was an issue where there was a councillor who was a tenant of a property that was owned by the council, and he was in arrears. And some members of the public felt that he was getting preferential treatment because he was a councillor. And it's just to clarify those issues, that if somebody thinks a councillor is getting preferential treatment in his private capacity, they can make a complaint to the Commissioner, and the Commissioner can resolve that to show, hopefully, that that everybody has been treated equally. And it's just to ensure that councillors make themselves aware that in their private capacity, if they do something that could bring their position as councillor into disrepute, that they be mindful of that. Or if they are engaging with the council in whatever manner, in a private capacity as opposed to their council position, that everything is above board. Basically, that's what it's trying to do.
I appreciate, Chair, that might be the intention of it, but I just feel the wording is much more wide-ranging than that. And obviously we'll not know probably until there's a legal challenge at some stage. But the wording of that to me would give very wide-ranging issues around councillors' code of conduct or councillors' conduct when not acting as a councillor. For example, if they set on a community group and were they acting in the interest of the wider community, or were they bringing their role as a councillor into disrepute?
The issue comes to arise if anyone who was at that meeting believed that councillor was acting inappropriately and bringing their position as councillor into disrepute. And it would only come into play if they decided to make a written complaint to the Commissioner. And the Commissioner then would make that judgment call. It's just to make councillors aware that they must be aware of their behaviour and how they are perceived by people who do not work in the council community.
For example, a local community group is applying for planning permission for a new play area, for the local community. And there's a councillor sitting on that committee, and someone says, well, maybe you would speak to planning officers. Now, probably doing that out of being part of the committee, but because he also knows the planning officers. And then someone else says, well, look, we feel he acted wrongly and brought his position as a councillor into disrepute because he was using his position as a councillor.
If a councillor is lobbying for a group, and members of the public also have that opportunity to put their case before a committee, there should be no objections to a councillor doing the same if he's representing his constituents. They have a voice, and he is the way to make that voice. So in that situation, if he was on that planning committee, obviously he wouldn't be involved in the decision making, but it's right that a councillor who represents his constituents about any issue, that he can take that forward to whatever committee, but he has to ensure that his position in relation to that committee is such that he is only putting forward information that will help a decision to be made, that he's not part of that decision also.
Just think it's open to significant difficulties, at least until there's a test case. I see that as one as we're going to have a legal challenge at some time.
Well, certainly it's something we will be liaising. It's something we'll flag up to the Commissioner, certainly, and over the next 3 to 4 years, up until it's reviewed, we will look to see if any of those issues have been arisen and how they've been dealt with. But it's more of a case as a flag for councillors to just be aware of that issue, that you are seen to be above board, that it's all about openness and transparency from the councillor's point of view. And if he is acting appropriately, then there shouldn't be an issue there. It may be just be clarification for someone who has raised it.
Okay. Chair, there's one other separate issue that I should have raised earlier, and it's around the surcharge. You did say that you're looking at surcharge and subordinate legislation.
Sorry, Tom, can I just interrupt you? I'll come back to you now. I just know, Lord Moore, I was wanting in the same issue just to keep it together, and we'll come back to you.
No, that's grand, yeah.
It's two minor points in relation to that discussion. I was just interested to hear the example you used for the councillor who happened to be in arrears, and it so happened that he rented a property from his local council. I can't understand why anyone would want to say he was given preferential treatment, other than the fact that he was the only person within the borough who was in arrears of rent. And I suspect, not knowing anything about it, I suspect he was not the only person in the borough who was in arrears of rent, which means again that he was just like every other human being.
Exactly.
And this issue whereby it's sometimes perceived that councillors or those in public life get some advantage because of their position, and their misdemeanours are skimmed over. So I would hope that he wasn't then being treated different because he was a councillor in the other one. In relation to this issue of serving on, if I'm a director on a development association, in whose interest am I the director? Am I a director in the interest of the community, or am I a director in the interest of the local council that sent me to be a director? Now, my understanding of it is, and I'm just wondering where the code comes in on this, if I serve on a district development association and I'm there sent by the council, my understanding is that I'm there to uphold and defend the council's position on that, not the community's position, which is unique in this respect, that you represent the community on one hand, and then one day you represent the council on a body because they've maybe they are given considerable subscriptions to that organisation. And then I know in the council that I served in for some years, we insisted on having representation on that body. So therefore, I was there looking allegedly, or supposed to be looking after the interests of the council, not the community. Not the community. Is the code clear on that?
Yes, I think the code is clear on that. It depends who you're representing. If you're there as representing your council, it's different than if you're there representing your constituents. You've been asked alone because that's your area. So it's up to a councillor just to ensure that whatever reason as to why they're on that committee, that they're clear why they're there and what they can and cannot do to ensure that there's openness and transparency exists.
Right. That's fine too. Thank you.
Okay, thank you. Sorry, Tom. If you want to
Sorry?
You wanted to continue then, where you were?
Sorry, mine was on the, my other one was on the surcharge issue. Just, and wondering when it's likely that subordinate legislation will come forward, and is it the current opinion of the department that the surcharges would be abolished?
It's something that the Minister will consider when the ethical standards system is bedded in for a few years, is the position.
Yeah. But is it the current opinion of the department that surcharges would be abolished?
We have the enabling power there. It will be a matter for the Minister to decide at an appropriate point whether it is appropriate to remove surcharge.
So there is no opinion at the moment?
I don't think until we've got the body of evidence from this new ethical standards regime built up, I don't think we are in a position to form an opinion or even advice to provide to the Minister.
But is it likely that decision would be made before the Shadow Council becomes full powers in May 2015?
No.
No? No. So there could be a period of time when councillors could be subject to surcharge?
Yeah.
Yes.
Okay. Thank you, Chair.
Okay. Thank you. Any members, any further questions on that? Or any other issue? Okay, that's grand. Thank you very much for your time this morning.
Sorry, just we dealt with the shadow arrangement.
That's coming next.
All right, sorry.
So I think if the members are content with no further questions, just have to put a question to the committee at this stage. That the Committee on the Environment has considered the Local Government Code of Conduct for Councillors and recommends that it be affirmed by the Assembly. Ask the members if they're agreed.
Great.
Thank you very much. Okay. Then we'll move on to the next item on the agenda, which is 4, departmental briefing on the shadow arrangements and draft local government transitional, supplementary and incidental provisions and modifications regulations Northern Ireland 2014. The draft regulations are at page 47, members, and the SL1 has also been tabled for information. The SL1 for these regulations was considered by the committee last week by correspondence only, and no comments were received from members by the department. The department is now proceeding to lay the rule. The examiner of statutory rules has not yet had an opportunity to comment on this rule, and we're welcoming them again: Linda McHugh, Julie Broadway again, John Murphy, and if John's not here, it's Lee Riley, okay, and Tracy Johnson. So you're very welcome. And if it ask, I'm not sure who of you would like to brief on this. If you want to go ahead.
Okay. We received 20 responses to the consultation, which made a number of comments, and if the committee's content, I'll just take you through the changes to the regulations that have been made as a result of the comments.
That would be useful. Thank you.
There has been one change to Regulation 2, actually not as a result of comments that have been received to the consultation, but provision 2.6 had originally said that if a statutory transition committee failed to appoint a clerk, that the clerk appointed by the new council would be done so by open competition and appointed on merit. The department is now aware that all statutory transition committees have appointed a clerk to the new council, so that provision has just been amended to take out the reference to statutory transition committee. It's staying in case, for some more unforeseen circumstances, one of the clerks that have been appointed has to stand down or needs to be replaced, and that's to provide that if the new council appoints a new clerk during the shadow period, it's on the same basis that they were appointed by the statutory transition committees. Regulation 3 hasn't been changed as a result of the consultation.
It's very slow, isn't it?
Regulation 4, then we received a number of responses which commented that there was a little bit of confusion between the provision, Regulation 4, which made provision for the provision of assistance from existing councils to new, and what I think at the time was Regulation 7, which made provision for assistance from Northern Ireland departments to new councils. So Regulations 4 and what used to be 7 and is now 8 have both been redrafted to take account of those comments, and as a result, Regulation 4 now deals exclusively with the provision of information and assistance by existing councils to the new, but the actual content of the provision isn't different to the policy intention that was made from the original draft. Regulation 5 is the regulation which provides for the application of the Code of Conduct to councillors of the 26 existing councils. It is the new Local Government Act 2014 that provides for its application to councillors of the 11 new councils. Again, there have been some technical amendments to that regulation, not as a result of the consultation, because no objections were received to the principle of applying the Code of Conduct to councillors of the existing councils, but in order to make sure that new existing councillors are guided by the new Code of Conduct, we had to provide for them to sign an amended declaration so that they have to abide by the new code. Regulation 6 provides for the filling of positions of responsibility in the new councils, and again it hasn't changed other than to provide for the new councils to make appointments to the partnership panel. That was as a result of a comment made when we brought the draft regulations to the committee. And another further amendment has been made to allow the new councils to appoint councillors to policing and community safety partnerships during the shadow period, and this was made on the advice of new chief executives. They've advised that in order for lay members to be appointed to PCSPs, the councillors form part of the appointment panel. So in order for the lay members to be in place for the 1st of April 2015, the councillors have to be there beforehand so that they can participate in the selection process. So we've provided for that to happen. A new Regulation 7 has been inserted as a result of comments received in the consultation, and this is to provide for the new councils to have mandatory standing orders in place from their creation. This was in response to comments received that the bill didn't provide for a process to be in place for new councils to appoint more than one committee at the same meeting. We got responses from 2 of the new councils that have indicated that they would like to appoint more than one committee at their first meeting, and so to provide for the procedure to be there for them to do so, we have inserted a new Schedule 3 to the regulations, which prescribes the process to be followed if you're going to appoint more than one committee at the same meeting. And really what that provides for is for that no one party can hold all seats on a committee, and that the political make-up of each committee broadly reflects the political make-up of the overall council. There's another provision in Schedule 3 which provides for another standing order to be inserted, which specifies votes that must be taken by a qualified majority. Most of the qualified majority decisions are already prescribed in the new 2014 Act, but 2 that need to be provided for during the shadow period are decisions that are called in on the grounds of disproportionate adverse impact under section 41(1)(b) of the bill. So those would be decisions subject to reconsideration because they had a disproportionate adverse impact on one section of the inhabitants of the district. And the other one is for the suspension of the council standing orders. Regulation 8. I've already mentioned Regulations 4 and 8 have been redrafted to separate the provision of information by existing councils to new and from Northern Ireland departments to new. And the only other change to that regulation is that it adds in the Northern Ireland Housing Executive, as we received a number of responses to the consultations which said that specific reference should be made to the Housing Executive, as they might have to provide information in relation to functions transferring to local government. Regulations 9, 10 and 11 were not changed as a result of the consultation, but a new Regulation 12 has been added, and that's to provide for a new council to sign off the statements of accounts of statutory transition committees after they're wound up, which is 28 days after the election. Schedule 1 also hasn't been amended as a result of the consultation, but I should say that Section 100, the exemption, the disapplication of Section 111 of the 2014 Act, which requires the Department to consult local government bodies on statutory guidance issued under Section 111. We received a number of comments objecting to the disapplication of that provision because local government felt that statutory guidance that was issued to it should be subject to consultation. Now, our response to that is that that provision has been disapplied for the transitional period only in unforeseen circumstances where we might have to issue statutory guidance at short notice, or for an issue that has arisen unforeseen. All the planned guidance, and I believe the committee received a list of the guidance that is planned to issue to the new councils during the shadow period. All the guidance that is currently scheduled to issue will be subject to consultation. This provision has been disapplied only in case guidance needs to be issued in short notice. And there has been one provision added to Schedule 2 which provides that existing councils may not make appointments to the partnership panel, just the new councils. And those are all the changes to the regulation.
Okay, thank you. Peter, you were looking
Yeah,
at
thanks. Just a couple of points just to clarify in terms of, first of all, on the nomination to committees, I see it makes reference then that more or less as far as practical they should be across the board sort of proportionate in that. Is there either sort of in the guidance of legislation anything sort of formula or is it simply being...
The formula in, I think it's Schedule 2 to the bill applies, so that's quota greatest remainder as a default method, and if qualified majority votes taken, it could be drip quota.
And it's on the basis then of that applying, if you like, if for the sake of argument the decision to appoint, say, 4 committees, a certain number, that would apply to that. But okay, just in terms of then something about in terms of the positions of responsibility during the new councils, there's obviously the election then of a presiding officer and presiding councillor and deputy presiding councillor. Presumably in terms of positions of responsibility, that would also then encompass if the one sort of appointment from an outside body will be to the partnership panel, plus presumably then, depending upon what's put in standing orders as regards the chairs of the interim committees, whatever it is. From that point of view, again, the schedules of the Act then will apply to those, so those would have to be then be, I suppose, default position to hunt and that sort of things for each of those. Presumably the intent would be that those would be run more or less, presumably if you like, in one batch, or alternatively it would work down the list that if, for example, at the first meeting you elected a presiding councillor and a deputy presiding councillor, and then we're going to decide, you know, a month or 2 months down the line who's going on the partnership panel or what committees you were going to have, it would then kick in, if you like, having already made those nominations, then it wouldn't restart as a...
No, it would just run on.
Go on,
yes,
in connection with
it
that.
would do, yes. And we are planning to issue guidance on, you know, to hunt, St Lag and STV.
Yeah. We had a lengthy meeting this day last week with the new chief executives to run through all of this so that they were clear on how the first few meetings of the new council would run.
And presumably then, just I suppose the final point, just from a practical point of view, see obviously then in terms of, in each case then the nominating officers, and that it will be either the nominating officer of the party, or if they, presumably if they produce a letter to the council saying it will be Councillor Bloggs will be doing it on my behalf for your council, that's the way it obviously would happen just on that front, on that side of it. Okay. Okay, thank you.
Any other members, any questions? If not, thank you very much.
Thank you.
Thank you.
Okay, members, so I just need to ask you now if you're content for the department to proceed with making the rule. So I'm putting the question that the Committee for the Environment has considered the shadow arrangements and draft local government, transitional, supplementary and incidental provisions and modifications, regulations, Northern Ireland 2014, and subject to the Examiner of Statutory Rules report recommends that it be affirmed by the Assembly. All agreed?
Agreed.
Right, thank you.
Reluctantly.
Sorry, Peter.
Okay, thank you. That takes us on to any other business. Any other business from members? If not, that's on to the date and time of the next meeting. And obviously, there's no meeting due to the elections this week. So the next meeting will be on Thursday, 29th of May at 10 a.m. in the Senate chamber. Thank
What
you.
date is that again, Jim?
29th of May.
Thursday?
Thursday.
I thought we were doing them on Monday.
Okay, thank you very much. Meeting's adjourned.
Voted, didn't we?